ki mō tahuna, koi te ngā moka pū o rongomai whenua rongomai tere, koi tamu wainuku, koi tamu waurangi, koi tamu ruruha papatūnuk, tahi e te ngā wātara, tahi e koi tama rehua tāne, me tahi koi runga, tahi e te nui, tahi e te roa, wirohi e te ata, oko mena tai, me rongo.
Me rongo. Kia ora. Well, kia ora everybody, and thank you for giving up your Monday night to learn a little bit more about this strange world that some of us dwell in. For those of you who we haven't met, I'm Jane Kelsey. I am one of the pukenga for Ngā Toki Whakarururanga, and was the technical expert on the digital stuff for the Y2522 Waitangi Tribunal inquiry and so on, and spend too much of my life dealing with digital trade law issues. And so one of the things that we talked about quite a while ago was trying to do some upskilling for people about what happens in the broad trade space, and with a view to doing a couple of things. One is to have those who are working in the digital space in other spheres being able to connect up to what is happening in the trade space and how it's impacting on what you do, but also to bring more voices in to seek to influence what is actually happening in the trade space, so that it's not just a couple of same olds harping on the same issues. So I have prepared a PowerPoint, but first we need to ask if you're happy for this to be recorded. Because we want to put this up on the website. And we will, I will hopefully have good time at the end for questions, but if you want to ask questions as we go, can you put your hand up? And if you need to vocally intervene because I don't see your hand because of the share screen, then please do. So, okay, so that's visible?
Aye.
Aye. Okay, so I'm going, whoopsie, I'm going to basically take you through, firstly, the context for how the digital issues have got into the trade agreement space, then a bit about what they do and what the rules are that you can see will affect what you're doing. And then I want to talk a bit about the Y2522 tribunal and what's happened after that. So hopefully it won't take too long. So as those of you who've watched Moana Maniaputu's video on the Ngā Toki Whakarururanga website, one of the problems we always have is that when you use the word trade, people just automatically kind of turn off. And so, and I can see Linnell smiling. And so the most important first thing is that trade agreements are a bit of a Trojan horse into which all sorts of things have been put. And so when we talk about e-commerce or digital trade rules, they're not really about the old-fashioned kind of trade agreements or notions of trade that we're familiar with, like importing and exporting slabs of butter. And they're not even about commerce, despite the fact it's described as e-commerce. They had to describe them that way to justify bringing them into the trade space. What they effectively try to do is to minimize regulation of the digital ecosystem to benefit the megatech corporations. And I'll explain how and why that's the case in a moment. So those of you, and I know some of you have quite a long history in understanding the intellectual property issues in the World Trade Organization or in the trade agreements. And that dates back to the 1980s and 1990s when major players, especially the US, decided they wanted to expand what trade rules were to develop global rules in areas that they had growing economic and commercial interests that served their mode of capitalism, but also served their major corporations. And so the first of these non-trade issues to get in there were intellectual property rights. And of course, that got included in the Y262 claim very early on. Areas of services, which were described as a trade issue whenever there was a foreign company involved. But then more recently in the 2000s, bringing the digital domain into the scope of trade. So effectively, when they did that, what they said was that e-commerce and digital trade rules and free trade agreements would basically say what kinds of laws and policies governments can and cannot apply to the digital ecosystem, including data, digital technologies, platforms, payment systems, code and algorithms, and that those rules would apply now and into the indefinite future, which of course was something of an advantage because most trade negotiators knew nothing about the digital space, and most governments were doing catch up on how to try to understand what was happening in that sphere, let alone working out how to regulate it. So if you could have rules that either froze the status quo or preferably even moved back what was there, that was going to be advantage to the tech companies. So why did they want to do this in trade agreements? And there's a number of very clear reasons. Some of you who've worked in the tech space for a long time will know that in the early days, the internet was going to be dealt with in the International Telecommunications Union, the ITU. And the corporations and the US especially didn't like that because it had multi-stakeholder, it had an attempt to balance various different considerations. It was quite public. And so trade agreements were a much more conducive space. Firstly, they were conducive because they exist to expand economic and commercial interests. So prioritizing the interests of capital was able to be achieved in the trade space as opposed to in other international fora. Secondly, someone got their phone on or something. Second, they didn't need to balance up all of these other factors. As we'll see, when it comes to balancing those commercial interests with other interests, the other interests take a secondary place. The third benefit was that these negotiations were usually conducted in secret, which meant that those who might want to raise issues about them wouldn't do so until the negotiations were basically a done deal. Fourthly, the negotiations are state on state. And so they don't involve a range of other stakeholders coming into the negotiating space. Although in the case of the US, it does have a number of committees of cleared advisors who have privileged access. A further advantage of the trade agreements was that firstly, they're enforceable. And secondly, they're enforceable not in domestic courts, but in offshore supranational tribunals, where those who act as the judges are trade experts. If a breach is found of the rules, they can result in economic penalties. Penalties on your exports, penalties on your services sectors, and so on. And the last two big advantages was that whilst in theory, every country in a negotiation is equal, powerful states have louder voices. And in particular, the US, as the home of big tech, was effectively able to set the agenda. And as we'll see in a moment, that is especially the case with digital in the US, and has been with intellectual property, because there's a revolving door between those who are in the US Trade Ministry, Trade Representative's Office, or the Commerce Ministry, and those who are in big tech. So just as they did with intellectual property rights, services, and so on, they saw that the trade agreements were a really good space to develop rules that would be hands-off for the digital sector. And the place where they started doing this was the Trans-Pacific Partnership Agreement. The main negotiator for the US, Robert Holliman, who led the e-commerce negotiations, had spent 23 years as the president of the Business Software Alliance in the US. And so he literally was double hatting as a lobbyist for big tech and as the negotiator on behalf of the US in the TPPA. And when it was concluded, he described it as the most ambitious and visionary internet trade agreement ever attempted. Now, the template that he worked to is known as the Digital 24 principles. And what the Digital 24, which is up on the US Trade Representative's website, did was basically codify the wish list from the big tech lobbies of what they wanted the global rules to be on regulating the digital domain. And these are some of the core examples. Obviously, if it's 24, there's more than that. But data was at the center of what they wanted to ensure rules against what they call localization. So firstly, to say that governments can't require data sourced in Aotearoa to be held in Aotearoa, or to be held in any other specified place that's not, for example, a data haven. And in some of the more recent agreements, some agreements say you can require a copy to be held here, but those who mine or scrape or whatever the data can take it wherever they like offshore as well. More recent ones say you cannot require it to be held even as a copy within the source country of the data. A related rule is that you can't require foreign digital operators to use local servers and other local computing facilities. So both of those together are taken as the data localization rules. And if you look at the recent EU FTA, you will see that the EU basically merges the two of them. Another prohibition on what governments can do. They can't require foreign digital operators to use local content or to use local providers or to employ locals who might get access to proprietary knowledge. Now, that's especially important for developing countries who are looking at how you do startups, etc. But it's also going to be very important for Māori data sovereignty, Māori digital governance. Another prohibition is on the requirement to disclose source codes or, in more recent agreements, algorithms contained within the codes. And that raises all sorts of questions, obviously, about issues of biases and issues around facial recognition software and what is done with the codes. But also raises issues that we explored in the tribunal about the very nature of source codes and the relationship between them and the digital ecosystem. There's also lots of anti-monopoly issues there. Another of the rules is that if you have a provider from offshore, you can't require that they have any local presence in Aotearoa. So that means there is no effective way to bring them under local law or the jurisdiction of regulatory agencies. That involves issues such as discrimination and so on, but it also involves abuses of taonga, such as the moko on the shower curtains and a whole variety of other abuses, and can't hold online platform operators liable for content posted by third parties, which some of you will know is a big issue in the US at present, but also raised a lot of issues about responsibility of the hosts and website owners for toxic material. So those and others are the core rules. And so you can see that they're basically modeled around the US hands-off approach to not regulating the big tech sector, set out in the old US Telecommunications Act, but globalized now. There are a couple of exceptions. One exception applies to the data issues for legitimate public policy, but they have to be the least burdensome on the providers, which means light-handed, voluntary kinds of obligations, including in areas like privacy, which is only seen as individual privacy, not seen as collective privacy in terms of concepts of whakapapa, and exceptions that will be judged by trade experts who wouldn't have a clue about whakapapa anyway. And there is the Treaty of Waitangi exception, but which doesn't apply to these kinds of rules because it only applies where more favorable treatment or kind of positive discrimination is being given to Māori rather than applying rules to the digital sector that are informed by mātauranga or informed by tikanga or informed by treaty obligations. And it's the Crown that decides if it's necessary to rely on that exception, and there's some other conditions. So one of the concerns that there is about this is even if there is the slightest doubt of whether treaty-based policies, laws, measures, decisions might breach any of these rules, the nature of the rules and the lack of protections and the enforceability by trade experts in offshore tribunals that might hit our export sectors can have what's called a chilling effect on the willingness of the state or the Crown to act. So what do these mean for Māori data sovereignty, Māori digital governance, and Te Tiriti? Well, the most fundamental issue, of course, is the collision of worldviews. And that's something that trade officials find really hard to grasp because they dwell in this world. They dwell in the world where the digital is a kind of technocentric, disembodied, decontextualized domain, where data is this kind of abstracted commodity that can be privately owned, that carries with it proprietary rights, where there are transactions in the digital space in commercial markets that are driven by profit and rights of ownership that come from network benefits, development of algorithms and so on, within a supposedly free and open internet, which is dominated by the first movers because they control the data and the space. By contrast, the digital space, from the perspective of Te Ao Māori, and I feel self-conscious in saying this to a group of Māori experts, holistic data is a collective imbued with whakapapa. The ecosystem itself has a Māori. The benefits carry with them responsibilities, that the system is itself, because of all of those things, subject to rangatiratanga, kaitiakitanga, and governed by tikanga. That is not the digital trade space. So there is actually no room in this space for this space. And that is a part of the dilemma that we keep having when we are asked to comment on texts that are developed in this space and how do they provide a treaty-based response. So let me just give you a handful of reflections that have come out both internationally, but in particular in the tribunal in dealing with this. This is not just, as you all know, an issue in Aotearoa, but the UN rapporteurs have been addressing Indigenous data sovereignty and data and governance in a variety of spaces. One, in terms of the right to privacy, looking much more broadly, making it clear that when we're talking about data are a cultural, strategic, and economic resource for Indigenous peoples, yet Indigenous peoples remain largely alienated from their collection, use, and application of data about them, their lands, and cultures. Existing data and data infrastructure fail to recognise or privilege Indigenous knowledge and worldviews and do not meet Indigenous peoples' current and future data needs. Current practices around open data and big data, whether under the auspices of governments or corporations, will likely move Indigenous people's data interests even further from where decisions affecting Indigenous people's data are made. So when these issues were dealt with in the 2522 tribunal on the TPPA, in the full hearing, the claimants had to identify 4 issues that out of the whole gamut of potential issues. One of them was engagement, one of them was secrecy, one of them was the plant varieties issues, and one of them was data. And it was really interesting that right from the start of identifying those issues, the Crown said, we don't even see why that's an issue. There are no issues in the e-commerce chapter for Māori. So, whereas in some other areas, they were at least conscious that there were potentially some treaty issues. They saw this as a treaty-free space. Despite the fact that there were in other parts of the Crown these discussions that were already beginning around data sovereignty and digital governance. So we had three expert witnesses, Putawa Biasinitule, Donna Cormack, and Kraitiana Tauru, who presented complementary and different evidence to the tribunal. And the Crown declined to engage with any of their evidence. It said it wasn't necessary to do so because they were going to present the correct legal interpretation of the chapter that showed there were no legal issues in the chapter for Māori. So they got an academic expert from Melbourne, who knew nothing about Te Tiriti, knew nothing about Māori and Indigenous issues at all, let alone in the digital space. And he presented what he said was the correct legal interpretation of the chapter. And I presented what was wrong with that. So the tribunal was very interesting because it had on it Hereni Mead. Oh gosh, now I'm going to have to remember who else it had on it. But it brought in an IP expert as well, who had expertise in trade, who was able to not get bamboozled by this. So there was an ability to try to connect up the collision of the two worldviews. And the tribunal, in the only part of the claim, was brave enough to come out and say that there was a breach. So what it said was the crux of the issue for this inquiry is the nexus between these e-commerce provisions in the TPPA, which got renamed the CPTPP, and the domestic policy context in Aotearoa, New Zealand. So what is the connection between what's in that agreement and what's happening in the domestic policy context in Aotearoa? At the heart of this issue is the question of governance and control of Māori data, which involves matters fundamental to Māori identity, such as whakapapa, mana, mauri, and mātauranga. Perhaps the most fundamental of Te Tiriti, the treaty guarantees to Māori, the tribunal said, is the right to cultural continuity. This is nothing less than the right to continue to organise and live in Aotearoa, New Zealand as Māori in accordance with tikanga Māori. The Crown, it said, when it negotiates these agreements, must actively protect Māori rights, interests, and responsibilities, not just be concerned with advancing Māori business and exporters' interests. These provisions, such as the localisation of data, were adopted by the Crown with minimal or no consideration of Māori rights and interests guaranteed in Te Tiriti. We are not convinced that reliance on the exceptions and inclusions is sufficient to meet that active protection standard. the tribunal went further in a really important way to say protection of Mātauranga Māori is not a matter for the Crown to decide or to trade off with other interests. Because Mātauranga Māori is at the heart of Māori identity, it is not an interest or consideration that's readily amenable to some form of balancing exercise when set against other trade objectives or the interests of other citizens or sectors. It's certainly not a matter that the Crown can or should decide unilaterally. It is precisely the fact that Māori interests might need to be defended that make Māori interests vulnerable, and highlights that before entering such agreements, the necessary domestic measures should be developed with Māori involvement. So not just keeping what we call the policy space open for the future, but not making these commitments until the domestic policy has been set. However hard it may be, the question for the appropriate level of protection of Mātauranga Māori in the international trade agreements and the governance of the digital domain is first and foremost a matter for dialogue between Te Tiriti, the treaty partners. So that's where the tribunal took us to, but then it wimped out. It said, for the first time ever, when we have a finding of a breach, we're not going to make recommendations for redress, because the Crown has set up various mechanisms through which it will try to resolve this. One of which would be Ngā Toki Whakarururanga, which was being established out of a mediation agreement in the tribunal process. Another was taumata, another was the Trade for All review. So what has happened since then? The claim showed that the Crown breached its treaty obligations. And the Crown has actually taken that seriously because there was a finding of a breach. But that does not mean that the Crown has stopped negotiating those agreements until the domestic policy has been resolved. Instead, the Crown has kept negotiating new free trade agreements that have similar rules and similar treaty breaches, including reviews of existing agreements that have those breaches within them. There has been some input from Ngā Toki Whakarururanga and possibly from Te Taumata, we don't know, that has led to some more protections in some agreements. In the UK agreement, we were told basically it's too late. We've put a review provision in there that refers to the tribunal report, but doing anything out of it will require the UK to agree, which is extremely unlikely. The EU was better. The EU has what we call a carve-out for measures adopted to address Māori rights, interests, duties and responsibilities under Te Tiriti, but still subject to some problematic conditions. And in the World Trade Organization, the big global rules space, they have put forward an exception that would actually be really good and is of the kind that we've drafted, but you have to get all the other countries to agree to it, which they're not going to. In addition, this has been done in secret. So one of the problems for Ngā Toki Whakarururanga is to have these inputs into these negotiations. A handful of us, Maui, Carrie, Jess Hutchins, myself plus Peter Mwana, I think that's us, oh, and Annette, we've had to sign these secret squirrel pacts that say that we won't tell anyone what's in what we're seeing. And it appears from some communications that we had today that even after the negotiations over, all the policy decisions have been made, we still can't tell you what input we made, even when it's not been accepted. So there's no accountability to you and no accountability of the Crown for what they have or haven't taken into account from what was said. Meanwhile, we're really aware that the domestic Māori digital sovereignty debate and development policies, privacy rules, etc., is occurring within the national space, but in total isolation from what is happening in these international trade negotiations. So to conclude, one good thing is that Ngā Toki Whakarururanga has, as part of the TPK Te Pai Tāwhiti funding, got some funding to collaborate with Māori in the digital space to develop resources, education, empowerment, and voice around these issues. And Ben Morgan, who is the new te hiwa for Ngā Toki Whakarururanga and who is on this webinar, is managing the project, and Ben can be contacted at the generic email for Ngā Toki Whakarururanga. Is that right, Ben, or wrong? Yes, that's right.
That's
yes,
right.
That's right. And so please send him any suggestions you've got and any people you can think of who might be interested in being involved in this mahi, which has to be concluded by June next year. But it's the first one off the rank, along with Hua Parakore. And so we're hoping to actually have some kind of hui around it before the end of the year. So that's kind of the story. Questions? Comments? Suggestions? Other than Aroha saying this is horrifying.
Yeah, well, it is horrifying because for all of the work we've been doing at the local level around data, around all sorts of things, what you've described just totally cuts across the whole thing. And I think most people would be completely ignorant of the fact that some substantial rights have been lost through these agreements. Gosh. What
we're going to do about it.
Is there any, in your dealings with MFAT, do you get a sense that they understand the gravity of the situation for Māori and for Crown Māori relations? Or are they blissfully unaware?
Maui and Kerry will have some views on this as well. They have taken this seriously because it was a breach. But what they're trying to do is to continue doing what they were doing and put in some protections rather than understanding that there is a more fundamental set of issues. Because this has become the one of the most important new issues in the negotiating space. And so even in the review of old agreements, they have been inserting this in the new versions of those agreements. And they're therefore dependent on the other parties to those agreements to agree. And one of the really scary spaces that's happening at present, apart from the World Trade Organization, is this new successor agreement to the TPPA with the US, known as the Indo-Pacific Economic Framework, IPEF, which no one really knows about, and which the US wants to conclude by November. And where there is a little bit of stuff that is up on the Ngā Toki Whakarururanga website about it. The good thing is that the digital part is moving very slowly because there's actually a war in the US Congress about digital and trying to break up some of the big tech companies and so on. And so it has slowed down. But yeah, the secrecy stuff is as bad as ever. And so part of trying to get the word out is to get those who have influence in the digital space to be able to start asking questions. We're not even sure how much those who are the other government agencies, the other Crown agencies, how much they know about this. Maui, Carrie, what's your sense of this?
I'll just jump in. Just on the one of the observations that I would have is just around when we think about what the tribunal said about Mātauranga Māori and the restrictive interpretation that the Crown seems to have taken with it. So whereas that view, obviously when it's Mātauranga, it should apply across a range of chapters and specific areas and trade agreements, they really have limited any way of looking at any kind of exceptions and language to the digital space. So Mātauranga, as it only applies to digital, not as it applies more generally as well. So there is, I think tomorrow night you might cover some of that as well, Jane. But it's just to say that all these things are kind of related. And it's probably really important that people really understand what the exceptions and carve-outs really do at the moment and what the benefit of the JSI, the Joint Statement Initiative, like the languaging and that, how that improves significantly on what we've got at the moment and why it should apply beyond just digital and e-commerce as well. I'll stop there and just let other people comment too.
Yeah, kia ora for that question, Aroha. So I guess my response is, do the Crown understand the seriousness of this and what we are saying to them? And I think on one level they do, even though it's very limited, I must say, and that is why it's essential that Māori have a seat at the table when these agreements are being negotiated, because we're basically conveying these, our voice, we're conveying these points to MFAT, and then MFAT are trying to then translate them across to whoever they're negotiating with on any particular agreement. So a lot of it is going to be lost in translation, and they've admitted that themselves. The second thing I'd say is that without doubt, and this has been my impression over the last couple of years, the MFAT will always give preference to what the big players are saying, because they say, well, look, we've got to get this over the line with the United States, with Canada, with Australia, and so that's always their comeback position. And it's just too hard, and they're getting pushed back, and I'm sure all of that's right, but I also sense that they're not trying hard enough either. In some instances they may be, but it's always Groundhog Day. Whenever we put something up to them, and they can demonstrate, they can certainly demonstrate that there's been consultation. And I think that's what they're aiming. If this gets to back in the tribunal or the courts, they can put their hand in their heart and say, look, we consulted with Māori on these things. So that's the second point. The third point is now completely escaped me, but so it really is an uphill battle. No, I've recalled the third point. The third point is what we faced in Y262. The Crown's job is to push back against everything that Māori are saying and seeking, and that's its role. I mean, it might sound very cynical, but that we all know that that's its role, especially Crown law. And I had 20 years of as legal counsel for Y262, so I've experienced every cross-examining MFAT witnesses and the dodging and deviousness and the lies and everything else, and so that's their game, because they have this de minimis approach. They don't want this transformation. They don't understand it. They don't see a need for it. And I think that they will do whatever they have to do because they're being forced to do it, either by dint of the Waitangi Tribunal finding breaches, a mediation agreement. They're not doing it because they love Māori or they want to really honour the treaty. They're doing it because they have to do it. And that has been the history of all the litigation, state-owned enterprises cases, the Māori fisheries cases, the broadcasting case, and it's exactly the same in this instance. So that's the reality we face, and we all know that. We all understand the game and how to play the game, but that's my take on it, and I haven't changed my view in 30+ years of the Crown's position. Certainly, compared, to be on a positive note, compared to say 20 years ago, 10 years ago, probably even 5 years ago, there has been an improvement in terms of their willingness to engage, and I do believe there is some good faith there, but the people we deal with, the policy people, they're got very firm instructions from their masters, their ministers, from cabinet, from the guys who wield the power, and they're going, shit, hold on a minute, we don't want to give too much to these Māoris because they still only represent 15% of the voting population in this country, and we still need to appeal to the, they don't want, neither National Labour want to get too far ahead of themselves because they're going to be attacked by the racists and the right wings and even the centre people. And that's been happening on co-governance and a whole range of other things. So we've just got to keep pushing forward as we've been pushing forward on that waka, sailing it beyond the horizon. And so anyway, that's a long answer to your question, Aroha, but you know all these things anyway.
No, thank you very much, Maui. I really appreciate that, and Kerry as well. You can only live in hope that something changes for the positive, and it isn't Groundhog Day every day.
Kia ora. Well, maybe to add one more thing that came up in this last week. In in response to each of the agreements that's come up, Ngā Toki Whakarururanga has been doing a treaty of Waitangi assessment against the 4 articles of Te Tiriti, not against the treaty or the principles. And inevitably that has meant that the agreements, most recently the EU one, have come up as failing the test. And in fact, officials were really quite upset at the submission to the select committee that PETA did based on the treaty assessment, that they said was just all negative, where they thought that there'd been major advances and there had been really good protections introduced as a consequence of the interactions. And, you know, so it's their expectations of what success looks like really very different. Okay, so Tanya is just headed off, and I was just going to add a response to what Ben had put in the column there, and maybe we'll flick it through to her as well, because Tanya was asking, for those who can't see the notes, about what are the specific research questions and research focus of the project. And as Ben said, it's really about creating accessible learning materials, including primers and videos and so on, that focus on the connection between data sovereignty, Māori data sovereignty, Māori intellectual property, and the trade agreements and rules. And so it's not a matter of doing more research, because actually a heck of a lot of that research has been done. It's more a matter of bringing together the work that's been done in the different spaces, and then working out how to put it into formats that can reach different audiences, as well as putting together something that can be a single resource that is given to the Crown, so that every agreement that comes up, it's not a matter of repeating the same old stuff over and over again in a technical way, and trying to educate them in a way that they refused. We put a proposal up to them for a 3-stage process that was Māori talking to Māori on this, then a small discussion with MFAT, and then a bigger hui that was Māori and the various Crown agencies. And they said they would only support the second one of those. And instead they would support some consultancy agency having a review of digital trade policy where it had one hui in Waikato. So, you know, this is an opportunity funded by Te Pai Tawhiti, but only about 60,000. So how far that can go is an issue as well. And kicking the ball off, really. So I will send some follow-up, or maybe Ben, you can send some additional stuff through to Tanya on that. And then, as Carrie mentioned, tomorrow night there's another of these webinars, which is on Te Paio and climate, which the stuff I've put together is actually a bit too much, but we may need to work out how to make it into 2. But if there are some of you who are interested in the more technical stuff of what's actually in the trade agreements, I'm happy to do a technical webinar where we can go through some of the provisions and you can see where the particular fishhooks lie. And Ben has also been recording this, so this webinar will go up on the Ngā Toki Whakarururanga website, and it would be great if you could share it around with people who you think might be interested. So we're exactly on the hour. If there's not any other questions, would someone like to give us a closing karakia?
I opened, so I should close as well, Jane. So I'm offering. But first, before I do, just want to thank you, Jane, for your words of wisdom and for putting the time aside this evening and passing on some really important information and knowledge to us all, because this is a space that many of us are fairly new to in terms of the trade kaupapa. So we greatly value your your time and expertise, and just to thank everybody else who's participated this evening. It's been a really good effort from all. So kino tātou. He honori he karoria he maunga ronga ki te whenua me te whakaro pai ki ngā tangata katoa. E hiwa manaakatia mai mātou i te au te pō ainga wā katoa. Hoko minatai me rungu. O mare, everybody.
O mare.
Kia ora koutou.
Kumari.
Mare.